So if you are applying as a representative of an estate, this is for our deceased family members, you must show that the person who died would have been eligible for the scheme as a primary claimant. So that's just like evidencing that they entered the UK before the 1st of January 1973. Again, we'll go into what can be classed as evidence in a few slides. You must show that the person who died suffered losses, including negative experiences, because they were unable to prove that they had a right to live in the UK at any specific time. So even if later on in life they were able to prove that they lived in the UK or later on got their British passport, if they suffered negative experiences prior to that, then or after that, they should put it on the application form. If the estate is administered in the UK, so say for example, if your deceased family member owned houses here or business or whatever in the UK, the claim must be made by an executor or administrator of the estate or by a personal representative of the deceased person. So say, for example, if my grandma, who is no longer here, who entered the UK before the 1st of January 1973, had property and business here, I would have to be named in her will or in any legal document as the administrator of the estate or executor of the estate. If there is no will or any legal document, then I must be given permission by a personal representative, such as a child or the eldest child or a sibling, in order to make the application. You must have written permission, and this must go off with the application. So say, for example, if you have a sibling group and you want to make an application on behalf of your parent who's deceased, then you need to make a decision of who that person is going to be, because only one person from that group, from the family, can make a claim on behalf of a representative of an estate. However, say for example, if there's a sibling group of 4 and you make an application on behalf of the estate of your parent, then one application can only be made for representative of an estate. However, you can all then make your own individual applications under a close family member. And as I said, in all of the applications, you have to, anything that you write, just like any compensation application or process, you have to evidence that which you're trying to claim compensation for. If, for example, you want to make a claim on behalf of a representative of an estate, but find out someone's already made a claim, you can, if you are the administrator or executor of the will, you can contest them in court. I wouldn't advise to do so. I'd advise to have a discussion and come to an agreement, but you can apply for assistance, financial assistance from the Windrush compensation scheme in order to assist you with this, with kind of challenging the person who's already made a claim for a representative of an estate. Yes. So a person who makes a claim on behalf of an estate must submit all of the following documents: a copy or photocopy of the death certificate of the deceased person that you're making a claim on behalf, a copy or photocopy of the relevant grant or probate of the letters of administration, proof of his or her own identity, so maybe their passport, driving license, or whatever. You may need to consider alternative forms of evidence. You must carry out a verification check if you have reasonable doubts about the authenticity of any documents. So if you look at any of the documents of your parent or grandparent and you're not sure if they're valid or not, then this is your responsibility. But you should only send any verified documents to evidence your application.